Mobile phone numbers. In the Slater case as Rich from Rich&Ruby continues to state incorrectly that UK or Spanish mobile numbers are public and have to be made private. This certainly is incorrect, and there is no public directory that correlates names to phone numbers. A reason for this is data protection. Both UK and Spanish mobile numbers are considered personal data under the General Data Protection Regulation, GDPR, and are not made public by default unless the owner has given explicit consent. What is GDPR? The General Data Protection Regulation, GDPR, is an EU and UK law that protects personal data. In force since May 25, 2018, it applies to all businesses and public sector organizations, handling EU-UK citizens' data, even outside Europe. Key principles: lawfulness and transparency. Data must be collected legally, with consent. Purpose limitation, used only for the stated purpose. Data minimization, only necessary data should be collected. Accuracy, kept up to date. Storage limitation, not kept longer than needed. Security, protected from breaches. Accountability, companies must prove compliance. What GDPR covers: personal data, names, phone numbers, emails, IPs, financial and biometric data, applies to EU-UK businesses, EU-UK public sector organizations, and foreign companies handling EU-UK data. Your rights: access and correction, see and fix your data. Right to be forgotten, request deletion. Object and restrict processing, control how data is used. Data portability, transfer your data. Penalties: fines up to €20 million or 4% of global revenue for violations. GDPR ensures privacy, security, and control over personal data. Here's how these numbers are treated under GDPR. Are UK and Spanish mobile numbers ever made public? By default, no. Phone numbers are protected personal data. Exceptions: if a person voluntarily publishes their number, e.g., business listings, social media. If the number is part of a public directory, e.g., business directories, but users must opt in. If required by law enforcement or regulatory agencies. Do mobile numbers need to be made private? If a number is wrongfully disclosed, GDPR requires it to be removed or made private upon request. Organizations must ensure they have a lawful basis for storing or sharing numbers, e.g., consent, contractual necessity. Individuals can request erasure under GDPR's right to be forgotten if their number has been published without permission. Are they covered under GDPR? Yes. GDPR explicitly includes mobile numbers as personal identifiable information, PII. Organizations processing phone numbers must comply with GDPR, ensuring security measures to prevent unauthorized access. Consent or legitimate interest before sharing or storing. Data minimization, meaning numbers should not be stored or shared unnecessarily. In summary, mobile numbers are not made public by default and are protected under GDPR. If a number is published inappropriately, the owner has the right to request its removal. The main reason law enforcement, as a public sector organization, can obtain personal data is due to specific exemptions for law enforcement and national security. These exemptions go beyond the standard GDPR exemptions, which are not covered in this video as do not fall into its scope. Exemptions for law enforcement and national security: under Article 23 GDPR, member states can impose further exemptions when necessary for national security, law enforcement, and criminal investigations, judicial proceedings, prevention of fraud, or financial crimes, public safety. Even with these exemptions, a court order is often required before personal data, such as mobile phone numbers and names, can be disclosed by an EU-UK business, such as a mobile network provider, to law enforcement authorities. Once law enforcement obtains this data, they are obligated to protect it as if they had collected it directly. They are also prohibited from sharing it with third parties unless a valid GDPR exemption applies, requiring legal justification for any further disclosure. The penalties and consequences for non-compliance with GDPR, including data breaches, are identical for both public sector organizations and private businesses in the EU and UK. In summary, the chances of law enforcement or mobile phone companies disclosing personal data to a YouTuber in the USA, such as Rich&Ruby, without a court order, are zero. Any such disclosure would be a serious GDPR violation, resulting in significant fines. I personally invite Rich to comment directly and clarify this inconsistency. Subscribers or viewers of his are welcome to pass this message along, and I look forward to his answer. Thank you for watching. Your feedback is always welcome in the comments below.